Matthew Mansour, Assistant Public Defender, with and on behalf of Exton. Here's my right. Exton, can you state your name for the record, please?
Deja Exton.
I have before me a plea form that indicates that the defendant would be pleading guilty to added counts 3 and 4. 3 being attempted possession of a loaded firearm in a motor vehicle, the 1-year offense. And count 4 being use of a controlled substance, also the 1-year offense, also a 1-year offense. On her successful plea to those charges, counts 1 and 2 would be dismissed. That's the court's entire understanding of the agreement.
That's correct, Your Honor.
That's correct, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give the truth, nothing but the truth, so help you God.
Yes.
State your name.
Deja Exton.
Ma'am, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. Is that correct? First is the charge and added count 3 of attempted possession of a loaded firearm in a motor vehicle. That's a misdemeanor punishable by up to 1 year incarceration, a $1,250 fine plus court costs, and mandatory forfeiture of the weapon. You understand that?
Yes.
Count 4 is use of a controlled substance. That is also a misdemeanor punishable by up to 1 year incarceration and or $2,000 fine plus court costs. Do you understand that?
Yes.
You also understand, ma'am, while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Freshour in the 14A4 District Court.
Yes.
Still wish to plead guilty?
Yes.
Were you in a motor vehicle?
Yes.
Did you have a weapon in that vehicle?
Yes.
What was it? Was it a pistol?
Yes.
Where was it located?
Under the seat. In the Kia Soto.
I'm sorry?
In the car, in the Kia Soto.
Got it. You don't have authority to carry a weapon in that fashion. It was in the passenger compartment, correct?
Yes.
You don't have permission to carry it in that fashion that you were carrying it, do you?
No.
All right. Did you also have in your possession heroin and or fentanyl?
Yes.
Had you used it?
Have I used it? Yes.
Had you used it? Okay, and you knew what you were using was heroin and or fentanyl?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty. 2 counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
April 23rd at 9 a.m. before Judge Freshour.
April 23rd, 2024, 9 a.m. before Judge Freshour.
Your Honor, my client would like me to address bond.
Go ahead briefly.
Thank you, Your Honor. Ms. Exton is Michigan born and raised. She's a Detroit resident. She's a full-time mother with full-time custody of a 3-year-old daughter. She works full-time. Not sure if she still has that job, but she's been employed there ever since November. To my knowledge, she has no open criminal cases. She's not on probation. She's not on parole. Her iChat is clean. Her record of appearances in this court, she's never missed a date. She does not own or possess any firearms. She has no plans to leave the state of Michigan anytime soon. We know she has not been perfect while testing on bond. She has spent the entire week in jail. She had a lot of time to think and reflect on her mistakes. All this time away from her child. Her 80-year-old grandmother is struggling right now, trying to help take care of that child. Your Honor, I'm asking for a PR bond on her behalf, allowing her one final chance to show you that she has learned from her mistakes, and she personally would like to apologize to you herself.
I can speak. Oh,
If you'd like.
I apologize for the way my attitude been perceived in this court.
Perceived?
I apologize. That's not who I am. I had a lot of time to reflect on my actions, and I learned my lesson. I don't want to be that person.
Your Honor, can I speak?
I don't know who you are.
Oh my God.
Yelling from the, who is that? Who are you?
I'm her mother.
Go ahead, man. I need your name.
My name is Heather Gregory. I'm here because she do have a 3-year-old child that's a special needs child.
I work all the time, over 60 hours. I just came back from out of town, and my mother is struggling to take care of her daughter, by herself because we just lost my father. If we gotta have on a tether or whatever, yard, we definitely need her home. Because my mother cannot take care of the child and I work too much.
She explained to you what she did?
She did,
She did not?
she did not. She did not tell.
Okay, let me just put it to you this way, Mom. She's in custody because she worked her way there. I mean, it wasn't just where I just threw her in. She was coming, she had issues over with an attitude problem over at Community Corrections and doing stuff there. I gave her a warning. Didn't lock her up. She was supposed to be testing. She was supposed to be doing everything. Next thing I know, she shows back up here. And she not only has abnormal creatinine levels, which would be positives at any event, I was still giving her the benefit of the doubt, but then shows up with cocaine in her system. That's how she ended up locked up. So the difficulties are not because of anything the court's doing, it's because of what she's not doing and then not telling me the truth.
I mean, like I said, I didn't know the Buddha stand, I've been out of town, I went out of town, you know, so I didn't know what happened, but, she was court, I know you had locked her up. And, like I said, she got a special needs kid, a daughter that has cerebral palsy, which my mother is trying to take care of. And it's hard, I know she's not perfect, and I know she has an attitude
Oh, yeah, she does.
problem, which, I mean, she might have got it from me, but I definitely need her home because I got this grandchild that needs her. So, all that, Your Honor, I'm just asking, can you please give her another chance? If I gotta watch her, I will, but I definitely need her home for my granddaughter's sake.
Any response from the people?
No.
Thank you. Thank you, Mr. Gunnar. Outside of that, Mr. Why should I even bother letting you out? Because I just have a feeling what's going to end up happening is Judge Freshour is going to have to lock you right back up.
I'm not gonna be the person that I was. And I had time to think in jail, trust me. I don't wanna be there.
$5,000 personal recognizance bond. I'll reinstate previous conditions.
You need to thank him.
Thank you, Joel Simpson.
Thank you, Your
You
Honor.
what?
She would get a different date.
Yeah. Different. But hold on. Reinstate the previous conditions. Also indicate that there's to be no further tests. I will also order a GPS tether. Home confinement, except work. I'll be sending a note to Judge Freshour, so young lady, if you mess up one bit, trust me, you'll be right back. Understood?
Yes.
Thank you.
Thank you, Your Honor.
This court proceeding centers on a defendant who appeared before the judge and formally entered a guilty plea as part of a negotiated agreement with the prosecution. Under the plea deal, the defendant pleaded guilty to 2 misdemeanor offenses: attempted possession of a loaded firearm in a motor vehicle and use of a controlled substance, both punishable by up to 1 year in jail. In exchange for this plea, the original and more serious charges were dismissed. During the plea colloquy, the judge carefully questioned the defendant to ensure the plea was knowing, voluntary, and factually supported. The defendant admitted she was in a vehicle with a pistol located within reach and acknowledged she had no legal authority to carry it in that manner. She also admitted to possessing and using heroin or fentanyl, confirming she knew exactly what substance she was consuming. After accepting the plea, the court ordered a pre-sentence investigation and scheduled sentencing before a different judge. The focus then shifted to bond. Defense counsel requested a personal recognizance bond, emphasizing the defendant's Michigan residency, lack of prior convictions, consistent court appearances, employment history, and her role as the primary caregiver for her young child. Counsel acknowledged her past bond violations, including positive drug tests and behavioral issues with community corrections, but argued that her recent time in jail had allowed for reflection and accountability. The defendant personally apologized to the court, stating she had learned from her mistakes and did not want to repeat her behavior. Her family member also addressed the court, explaining the hardship being faced by the child and elderly family members if the defendant remained incarcerated. The judge, while clearly frustrated with the defendant's prior dishonesty, attitude problems, and repeated violations including abnormal creatinine levels and a positive cocaine test, ultimately decided to give her one final opportunity. The court granted a $5,000 personal recognizance bond, reinstated all prior bond conditions, imposed GPS tether with home confinement except for work, and issued a strict warning that any further violation would result in immediate incarceration. The judge made clear this was not leniency without consequence, but a final chance, stressing that failure to comply would lead to swift and serious repercussions. For more information, like and subscribe to my channel.
Well, this is the Slater matter in regard to counsel. State your appearance.
Good morning, Your Honor. Tiffany Hughes, P79762.
All right. Ms. Hughes, and just so that we're clear on the record, this was the show cause hearing originally set by the court regarding your failure to appear for Mr. Slater's preliminary examination. I further indicated to you that it was troublesome for the court that this got sat, and that at the time that it was sat, court is aware that you knew that you had taken employment elsewhere, and that Mr. Slater then appeared for a preliminary examination, in effect with not, I won't say without counsel, but without counsel that was ready to proceed regarding his statutory right to have that hearing. Further, that ultimately the court was also informed, at least by Mr. Slater, that he had not been communicated with by you except for the initial time, had not been communicated about your impending departure when he then appeared before the court. Since that time, I will also indicate to you that because of this, and I'm only dealing with the Slater matter, but there were other instances during the same time, one being in 15th District Court, and I believe one being downtown before the Circuit Court, where you were counsel of record and did not appear for those proceedings. I will say also specifically regarding this proceeding, that on the date and time set for the preliminary examination, that this court, through my office, tried to contact you numerous different ways, and we did not receive a response. The ultimate thing in that is that Mr. Slater's preliminary examination, which I believe was ultimately waived, but he did not have his preliminary examination, and his proceeding was delayed by, I believe, approximately 2 weeks. So the court has issued the show cause to see why the court should not hold you in contempt and issue sanctions.
So, Your Honor, I did inform like the people that assigned me the case, I did inform them and I let them know what case I had outstanding. I was then contacted by the attorney that would be subbing in for me, and I gave him all of the information. I sent it to an email as soon as he contacted me. It was like almost like simultaneous. So
But what day was that?
the day it was, so they contacted me, well, the sub attorney, they contacted me on March 8th, and I sent it on March 8th. Substitution attorney was Bernstein,
Yes.
and I sent him all of the discovery, everything that I had on Slater.
And
And beforehand, I went to the special counsel office and I just gave them a list of everything that I had outstanding. And
but counsel, that your obligations under the court rule are to still appear. I mean, because the preliminary examination said that was on the March 8th. That was a Friday. Preliminary examination was set for that Tuesday for Mr. Slater. And Mr. Slater had not been informed when you were doing all of this.
And then I spoke with his mother and I informed her, and then I gave her the new attorney's information with Mr. Slater's mother.
Why would on February 29th, you have set this for preliminary examination when you knew that you would not be counsel, that you had accepted other employment?
I thought that another counsel would sub in for me in time. Because like I said, I informed special counsel who assigns this, I informed them, so I thought that another
On what
attorney.
day did you inform them?
This was February 22nd, I believe. February 22nd, I believe.
Then why do I not receive a motion to withdraw until March 11th?
I don't know, Your Honor.
Well, you're the one, counsel, you can't just say I don't know, because you're the one responsible to withdraw from the case. Regardless of the fact that the MAC office is the one that gives your name, it is your obligation. It's not their obligation. You would agree with that. I mean, you're the attorney of record.
Understandable.
But if you knew on the 22nd of February that you were going to be withdrawing from cases, I don't, on this matter, I don't get anything until March.
My apologies. I didn't know, like they said they did all the motions to withdraw for me, so I thought they would have got it sooner. I did inform them February 22nd, and I thought that substitution counsel would be in before then.
Ms. Hughes, if that's true, then why on February 29th, this would have been a week after, do you appear and set the case for preliminary examination?
Because I thought.
And not inform the court, not inform the defendant, not inform anybody that you won't be counsel of record?
Again, I thought that it would be substitution counsel, so I really thought that it would be, so a counsel would be substituted in, and that
doesn't even make any sense, Ms. Hughes. If on the 22nd of February, you know, and you say you informed them of that, you appear on the 29th of February, do not do anything to withdraw, do not do anything to place your client in a position where they're not worse off. What you do is you set him for preliminary examination. at a time you know you're not going to be counsel. So that doesn't even make any, what you're telling me doesn't make any sense. So why didn't you do something on the 29th?
Okay, I was still trying to get all of my other ones in order, not just this court, but just all of the other courts that I was trying to tie up those, and all got dropped.
It doesn't make any sense to me, Ms. Hughes. And I want to give you the benefit of the doubt on this, but if you're telling me on the 22nd of February that you knew that you had other employment, that you informed, you're saying at that time, without turning this into a full-blown hearing, but I'll bring them down, that on the 22nd, that you informed the MAC office. You appeared then on Mr. Slater's case on the 29th, set it for a preliminary examination, say nothing to the court, nothing to Mr. Slater or anyone, that you will not be the one handling the preliminary examination. You are still the attorney of record. The 12th comes along, because that's the date it got set for March 12th. You do not appear on March 12th. We sent you various communications during that day. You didn't appear before the court on the 12th and just did nothing. In fact, counsel, you don't know on the 12th that other counsel has been appointed to represent him.
I did know on the 12th, I sent the other counsel the info on the A. So it was my understanding that was his other counsel. If he communicated to me and asked me for the discovery,
You are not released from an obligation until the court releases you. You do know that, don't you?
yes, and I thought that with him calling me and informing me that I was released. My apologies, the ball got dropped.
The ball didn't get dropped. I don't have an order even to sign if I wanted to. But I don't even get an order to me that I eventually signed until, which is your obligation to withdraw, not the MAC office obligation to withdraw. I don't get an order until the 12th, the date of his prelim. And then they have to adjourn the proceeding out. Anything else you want to say?
No,
And Ms. Hughes, I'm just going to let you know, I don't appreciate also that when my staff reaches out to you, when this court reaches out to you, irrespective of anybody else, we got no response from you. None. We sent emails, we made phone calls.
I didn't get a phone call.
We did not get a response. Anything else you want to pay? I was trying to find a way where this was not something that I should sanction, Ms. Hughes, but I don't see that. Anything else you want to say?
Nothing further.
I'm going to sanction you to $500. That's to be paid to the court. When can you get that paid to the court?
In about 2 months.
Pardon?
I'm gonna need about 2 months. Is that something I can pay online or?
You'll have to ask the clerks up front. That's to be paid by June 21st, 2024. Thank you.
During this court session,
Honor,
The judge conducted a show cause hearing involving attorney Tiffany, accused regarding her failure to appear for Mr. Slater's scheduled preliminary examination and related professional obligations. The court outlined serious concerns, noting that Ms. Hughes knew as early as February 22nd that she had accepted new employment
I'm wondering
and
why
would be
you're saying
leaving her
that to me.
position.
I mean, if it were stolen
Yet she still appeared
10
in
years
court on
ago as
February
opposed to
29th
the day
and set
before,
Mr.
will it
Slater's
matter
case
for me?
for a preliminary examination without informing the court. The defendant, or taking formal steps to withdraw as counsel. As a result, Mr. Slater appeared for his preliminary examination on March 12th without prepared counsel, delaying his statutory rights and causing unnecessary disruption to the proceedings. The judge emphasized that an attorney remains counsel of record until formally released by court order, and that it is the attorney's personal responsibility, not the assigning officers, to file a motion to withdraw and ensure continuity of representation. The court further noted that repeated attempts by court staff to contact Ms. Hughes on the day of the hearing went unanswered, compounding the seriousness of the misconduct. While Ms. Hughes explained that she believed substitute counsel would be appointed and acknowledged that the ball got dropped, the judge rejected this explanation, stating it was inconsistent with court rules and professional responsibility. The court stressed that such failures undermine the justice system, delay proceedings, and place defendants at risk, finding no adequate justification for the conduct. The judge imposed a $500 sanction payable to the court, ordering that the amount be paid by June 21st, 2024, and made clear that the sanction reflected the court's obligation to enforce accountability and protect the integrity of judicial proceedings. For more information, like and subscribe to my channel.
About what weapons would cost. And you have to set aside your knowledge on it. You have to do that. Well, I certainly can set aside my knowledge, but I'm just saying, I mean, there's other indicia. The fact it wasn't registered. I mean, okay, because it wouldn't have come back stolen if it had been. That's the reason I can say. Well, yeah, okay. Well, I'm not arguing that the weapon wasn't stolen, but I'm arguing that they haven't shown that he knew it was stolen. I'm arguing that they haven't shown anything that says he had the knowledge that this is a stolen weapon. Okay, so it wasn't registered. All right. So how long had he had the weapon? We don't know that. There's no evidence to say how long he had it. There's no evidence to say that he didn't just pick up that weapon the day before and maybe he was going to register if he thought he could. None of that's there. Buying a weapon doesn't, even if you buy it under illicit means, doesn't mean that you know it's stolen. It just means you bought it illicitly. It means you bought something you shouldn't have bought. That doesn't mean that it's stolen. Okay. So the bottom line is, Your Honor, they do have to put on some evidence, or some evidence from which it could be reasonably and logically inferred of his knowledge of the nature of this weapon, that it was in fact a stolen weapon. None of that is here. You can talk about all you want. Well, he shouldn't have paid as much as it. It was such an ugly weapon. Why would he pay that much? Or it wasn't registered. Those things don't matter if they don't show that this person, this individual, had knowledge that this was a stolen weapon. Could have been something somebody found, somebody tossed away. Could have been. But it's knowledge or reason to know. All right. Well, right. And so, all right. I love that. Wouldn't that really be an issue of fact? No. Given all the circumstances? No, and no, because they have to put on some evidence from which you can infer that element. They have to put on evidence of all the elements. And the necessary element here is that he should have known or had a reason to know it was stolen. None of the things that they talk about will lead to that conclusion. None of the evidence they put on will lead to the conclusion that this individual, knew or should have known this was a stolen weapon. He might have known that he bought it illicitly. He might have known that he shouldn't have a weapon, but none of that says that he knew that this particular weapon was a stolen weapon. And that's what they have to show. If they're going to say that he should be bound over on receiving and concealing a stolen weapon, that particular knowledge. And it's just not there. All right. So as to the others, the carry and concealed weapon, possession by a felon, I think those are actually issues for the trial. But the one it's not an issue because they haven't made an issue because they have not put in sufficient evidence for you to logically infer that he had knowledge that this was a stolen weapon.
Thank you, Your Honor. When we were here on April 2nd, 2024, Trooper Chowdhury testified. During his testimony, I admitted the defendant's admissions to Trooper Chowdhury. Trooper Chowdhury testified that the defendant told him that he had purchased the firearm 2 days prior and that he had purchased the firearm from somebody by the name of Jay, that he wouldn't provide any further details about who Jay was or the information about the sale. So when I layered that prior testimony on top of today's testimony, the defendant paid too much, $125 for a high point, and that the high point was in poor condition, in this painted condition, and that it's returned stolen, I do certainly have at least a probable cause and a question for the jury as to whether or not this defendant knew or had reason to know that this firearm was stolen.
Kind of not want to get Jay in trouble with illicit weapons sale. It's not knowledge that it was stolen. That's a leap. It's a huge leap.
What's a huge leap? That some guy named Jay sold an overpriced weapon to somebody, that's a huge leap as to whether or not I know it's stolen.
Exactly right. It's illicit sales. Maybe he knows he's not supposed to have a weapon. Doesn't mean he knows it's stolen. Again, he's not trying to bring everybody else down with him. He'll just end up in the kitchen.
Thank you, Mr. Brown. Having heard all the testimony and as to count one, certainly the people who has sustained their burden and the court would find the defendant overstaying trial on count one. As to count two, there's been much talk about the receiving and concealing and the defendant's knowledge of that. There is certainly, people haven't shown his direct knowledge necessarily. There is certainly evidence by which a fact finder could infer that the defendant had knowledge. One, the purchase of a firearm at an amount, by the testimony of Mr. Spencer, at an amount more than really twice what he paid, what he would have paid for that same weapon, having knowledge of that weapon. The fact that there's an admission that he purchased it from some guy named Jay 2 days prior. The weapon is not registered, so it comes back stolen. All of those things, I think, can be used to, at least by a fact finder, to infer that the defendant had some knowledge that this was indeed a stolen weapon. So for those reasons, the court would find that the people have indeed sustained their burden as to count two and would bind the defendant over on that charge also.
Yeah.
Mr. Brown, with the addition of the April 22nd to 23rd day,
No way the presentation information. My client was still in there.
defendant having way of reading and presentation, court will enter his not guilty plea as to both counts. Pre-trial in this matter will be set for
June 4th at 1:30 before Judge Conkey.
June 4th, 2024, 1:30.
During this court hearing, the judge considered whether the prosecution had presented enough evidence to bind the defendant over for trial on multiple firearm-related charges, with particular focus on the allegation of receiving and concealing a stolen weapon. Defense counsel argued that while the prosecution established that the firearm was stolen, they failed to prove a critical legal element, that the defendant knew or reasonably should have known that the weapon was stolen at the time he possessed it. Counsel emphasized that there was no evidence showing when the firearm was stolen, how long the defendant had possessed it, or any circumstances proving knowledge, explaining that buying a weapon illegally does not automatically mean the buyer knows it is stolen. The defense further argued that the price paid for the weapon, its poor condition, or the fact that it was unregistered were not enough on their own to establish knowledge, especially without proof that the defendant had expertise in firearm values, In response, the prosecution relied on prior testimony from a state trooper who stated that the defendant admitted purchasing the firearm just 2 days earlier from an individual known only as J, refused to provide identifying information about the seller, and acquired the weapon in poor condition at a price significantly higher than market value. The prosecution argued that these circumstances, when viewed together, created sufficient probable cause for a fact finder to reasonably infer that the defendant knew or had reason to know the firearm was stolen. After reviewing all testimony and arguments, the judge ruled that the prosecution had met its burden at the probable cause stage for both charges, while acknowledging that direct proof of knowledge was not presented. The court found that the surrounding facts, including the recent purchase, lack of registration, questionable source, and price paid, were enough to allow an inference of knowledge by a jury. As a result, the defendant was bound over for trial on both counts, entered pleas of not guilty, and the court scheduled the case for a future pretrial conference. For more information, like and subscribe to my channel.